Thank you, Kyle. Appreciate that very much. Next, we're a little ahead of schedule, and I suspect that Bill will need all the time we can give him for his presentation and the questions that are sure to follow. So with that, I'd ask you to join me in welcoming William Donohue, who is the Associate General Counsel Environmental for Health and Safety at Exelon. We heard a little bit about 316B yesterday, and I think we're going to take a much deeper dive, pun not intended, about the water-related issues. So with that, Bill, the floor is yours.
Thank you. That's really dangerous, giving a lawyer 15 extra minutes. Suffice to say, I'll probably use it.
This is your ahead laser pointer back, and it's got a little bit about a 1 second delay. So
Okay. All right, great. This is about the third or fourth time I've given this presentation at this particular conferences. I've also done it at other conferences. And I'm concerned that I'm sort of becoming the gloom and doom prophet, because I would talk about the proposed rule which came out in, I guess it was 2011, and just all the horrific scenarios that, that could possibly develop into the final rule. And as Quinn Shea said yesterday, we did okay. If you look, and I'll have a scorecard and I'll cover the prior issues, but it's sort of okay relative to what? You know, in some respects, if you've been doing this as long as I have, we got back to where we were in 2004 with a rule that industry supported, and for a number of reasons it was vacated, and then we went into a proposed rule phase, which became very problematic, and we've been able to turn that around, I believe, for the most part. There's still a few problematic issues in the new rule, but I'm just happy to stand here and say we have a final rule. Having promised it so many different times, and having been on the cusp of it so many different times when I gave this presentation in the past. This is going to be a little bit of a change up. Obviously, it's water. It's not the air issues. I'm an attorney. There will be a certain legal bend to this presentation, which I think will be helpful because it will show how the regulatory process works once a rule goes proposed. And we're going to see that with the greenhouse gases. We're going to see that again with CSAPR. We're seeing that now with MATS. And 316B will be no exception in terms of the litigation path that it will follow, in addition to the rollout of the regulatory compliance schedule. Quinn alluded yesterday to the fact that the approach that the EEI companies took was to respectfully advise the EPA what industry needed in the rule, not what we wanted. And I would take that a step further and say that we did so in a constructive way. We said this is what we need, and we see this is how you can get there from here. And I think that really struck a responsive chord with the EPA, particularly at the policy level. I like to do a shout out for my colleagues at PSE&G. They were with us every step of the way, and actually we're out front on preserving cost benefit under the existing rule. But it's important that when you're dealing with the regulators, you do so in a constructive way. You just can't say, no, it's impossible, you're shutting the industry down, never work. That mantra gets real tired real quick. And it's important that when you go into the regulators, you be honest and you develop credibility. So that when you advise the regulators, no, this cycles of concentration thing to determine what a closed cycle cooling system is just really bizarre. And when you start to talk with them about why that creates a problem, then you've developed that trust, and they say, okay, how can we fix that? And so I'll give you examples of how that happened. Here's an overview. I'm going to give a background of 316B. In this regard, I think it's important to know where we've been, to understand where we might be going with respect to the final rule. And in that regard, I'll go over the proposed rule and industry's comments and concerns with the proposed rule. And then I'm going to put up the slide that I've always ended the prior presentations with, which is what I call a watch list of key issues. Saying, okay, when this rule comes out in 4 days, this was back in November, these are the key things that we need to look at and examine, because these are the significant parts of the rule that could really impact the operation of cooling water intake structures at steam-fired generation plants. So I'll put up that list, and I'll sort of give a summary of where we came out on them as sort of a scorecard, and then we'll take a look at the primary provisions of the final rule. I want to caution you, given the time limitations and probably the limitations of my own expertise, even though I've been following this rule for 10 years, this will be a very high-level overview. There's a lot in this rule, and if your company has plants that are subject to this rule, or if you're consultants or law firms and have clients that are subject to this rule, even though it's not yet been published in the Federal Register, it's very important that you get out in front and on top of this, because there's a lot of work that needs to be done in terms of implementing the rules requirements and implementing it in a way that is optimal from your facility's perspective, because there's a lot of flexibility in this rule, and it really requires that you get out in front, understand what the requirements are, and understand the nuances. Okay, this is a busy slide. The thing that always interested me or amazed me about 316B is that the statutory section itself is very simple. It's only 3 lines in the statute. And the gist of it is, I've put up on the first bullet, that the location, design, construction, and capacity of cooling water intake structures must reflect the best technology available for minimizing adverse environmental impact. That's all it says. There's very little in the congressional record. There wasn't a lot of guidance. So if ever a statutory provision called out for discretion in terms of the permitting director, the state permitting agency in most cases, this was it. Some key aspects is that it's enforced through your NPDES discharge permit system. So if you don't have an NPDES permit, you're not subject to 316B. But this also means that it goes into the purview in most states, except for, I guess, Massachusetts, to the state permitting directors. So when you're renewing your permit, or even, when you're renewing your permit, even prior to the rule, 316B was required to be considered and addressed in your permit. What's adverse environmental impact? And I'll give a neat graphic for the non-technical people in a minute. But the way the agency has approached the adverse environmental impact is to take a look at two impacts. One is impingement, where the aquatic life gets trapped up against the screens, traveling screens or trash racks or whatever is in front of the cooling water intake structure, and entrainment for the smaller aquatic organisms, larvae, etc., that get drawn into the intake and through the cooling system. When this case went before the Supreme Court, when the rule went before the Supreme Court, looking at the extent to which cost-benefit needed to be taken into account in determining what the best technology available is, Justice Scalia, in his own inimitable way, said impingement, and when he wrote the opinion, said impingement is when the fish gets squashed against the screens, and entrainment is when they get sucked in. So that's always an interesting way to keep that in mind. Another interesting part of the rule, and this is a quote that I attribute to Christy Bullitt from Hunt and Williams, who represents UAG. Fish are not pollution. Well, obviously that's a pretty obvious statement, but the point is that you're not talking about a technology like air pollution or effluent pollution, where you can put technology at the end of the pipe and achieve a certain fairly predictable result. What we're trying to do here is minimize the impact of the fish coming into the being drawn into the cooling water structure, and there's a variety of technologies that are available to do this, but a lot of them their effectiveness vary according to site-specific characteristics of the facility. So wedge wire screens or velocity caps, while they may work in certain type of aquatic environments, don't work in all aquatic requirements. The best technology, and I don't think that there's any argument here, the best technology to reduce impingement and entrainment is closed cycle cooling. But the issue is it's not available at all facilities. It's extremely difficult to retrofit an existing facility with closed cycle cooling. I think it's only been done at one facility in the country, and that facility I think is about to close. I don't know whether there's any correlation there. I believe that's Brayton Point up in Connecticut or Massachusetts. But the point is that it's not available. Either it's cost prohibitive, there's no space, it's just economic. It's just not economic to put closed cycle cooling in. It has too much of an impact on the operations of the plant. So that creates an issue, and there's no one-size-fits-all technology solution. But sort of lurking in the background throughout the entire regulatory process has been the question of whether existing plants that have once-through cooling systems will be required to put on closed-cycle cooling. That is what the environmentalists have urged, those groups, the Riverkeeper, that have challenged the rule, is that there should be a national standard. It should be closed-cycle cooling, and so that sort of has lurked in the background throughout the history of the rule. I always like to go through some graphics. If I'm being too basic here, I apologize. I did this presentation once at an EEI ABA conference probably about 8 years ago, and I used some of these pictures, and afterwards one of the financial analysts in the room came up and said it was the best presentation he had ever seen because of the pictures. And I'm a very visual person. I have to see something to really understand it. Well, this is your basic cooling water intake structure. You can see here, these are your trash racks. This keeps trash and other debris from going into the cooling water intake. Behind that are traveling screens that rotate. In all likelihood, these screens are not modified screens in that they're not designed to minimize impingement mortality. That is, they sort of collect the aquatic organisms that get trapped against the screens, spray off the screen, and then just discard the aquatic life. So, but this is your basic structure. Doesn't want to seem to leave the picture. Here's the nifty graphic of impingement and entrainment. Very scientific here, but here's the traveling screen, and impingement occurs, as you can see, when the fish hit the screen, and if the screen is a modified wrist drop screen with a fish return system, they'll drop into a bucket here, and they will be put into a fish return system and returned to the source water body. If not, then they'll end up, as I said, in the dumpster. If they're small, they will go through the screen and then through the cooling water intake system and subject to a lot of various stresses as that occurs. There's different ways to approach impingement and entrainment. Some of the sample technologies for impingement are screening systems, and we'll look at these in more detail. But here you see a graphic of the traveling screen. Fish hit the screen, return. They fall into a bucket and then be returned to the source water body very gently, and of course and caring with a lot of care. This is the fine mesh screen. It must be small enough so that it can capture the smaller aquatic life. It won't capture it all, but it's smooth. It's designed to prevent scaling or injury to the fish. And here is the fish return system. So here from our prior picture, there's the trash racks, there's the traveling screens, and there's your fish return system, which is really just a flume that will return them to the source water body. Here's a graphic of how the traveling screen works. You can see the fish coming in, hit the screen, drop, and then into the fish buckets, smooth mesh. And I love this depiction here. It's the modified wrist trough with Fletcher fish screens. I don't know whether it was Ristroff or Fletcher that patented it, but the person who put this curved front on the bucket is making a lot of money, because as you can see, it virtually eliminates turbulent vortexing within the fish conveyance zone. So like these guys, that they just go round and around and around in that bucket, and they're not happy. They got their eyes closed. These guys, man, they are living large. I mean, that's like the equivalent of my Barco lounger at home. They're being gently rotated around, and they're happy, and then eventually they'll hit this. Eventually, they will hit the fish return system, and they'll be returned to the source water body. This is what it looks like full blown. Sort of essentially the same picture that you saw earlier. The advantages are that there's good operational experience. This is a technology which is widely used. There's good experience. EPRI has looked at them a lot. You can predict within a certain somewhat within a fairly tight range, although it's not really precise, what kind of experience or impingement mortality reduction you're going to get. And it's effective for most species. Your fragile species like gizzard shad and others will not withstand this, but it's good for most species. The disadvantage is that it's only for impingement, so even if you solve this issue, you still have the entrainment, and we'll get to that in a minute. It's site-specific. Not all intakes can accommodate the system. There's operation and maintenance that needs to go on at these systems, so there is an ongoing expense. And then there's the problem of predation, which is all the birds that will swoop down and take the fish out of the tray, the flume, or stand by at the flume entrance into the water body, and there's sort of like a feeding frenzy. So the EPA says in the final rule that you have to minimize predation when you have one of these systems, and the idea would be that you'd have to, I guess, cover it, and I don't know what else you could do, but in any event, those are the disadvantages. I'm going to go quickly through some alternatives. These are barrier nets. As you can see, it's a netting that is out in front of the intake. There's some operational experience for this. You don't have to change your intake structures. Very cost effective, and it can repel many species. The disadvantages are that you can't use them in all locations. You can't extend too far out into a ship channel here if you're on an active water body. It's only for impingement. Very site specific, and they're high level of maintenance required because they get fouled with seaweed and other things. So it seems like you're in some locations constantly out there cleaning off the screens. Offshore intakes or velocity caps. This became a big issue in the regulations, in the regulatory process. This is an offshore intake, and if you look at the picture on the right here, you can see the problem is that the current, the intake draws in aquatic life, et cetera. So the solution is to put one of these velocity caps on top. So essentially what it does is it prevents the fish from getting in, but also keeps the current, it keeps the current above the cap does not result in the fish being drawn into the intake. So it makes the horizontal current there sort of a fish avoidance type of technology. Again, requires a deep offshore intake and a strong current for this type of thing to work. But there are some facilities that have these, and they were not specifically approved or authorized under the proposed rule, and this became a big issue as to how to address, would this be considered best technology available for these existing systems? You don't want me to leave the velocity. Entrainment. Okay, so we covered impingement. Entrainment, of course, is when the smaller species get sucked into the intake system. The best way to reduce entrainment, as it is with impingement actually, but entrainment in particular, is to reduce your flow. And the best way to do that, of course, is to recycle, to have closed cycle cooling. It can be cooling ponds or lakes. Exelon has 3 facilities, 3 nuclear facilities that use man-made cooling ponds as the essentially the method to cool the water in a closed cycle way. Natural draft cooling towers, mechanical draft, wet or dry. Of course, dry towers are much more expensive than the wet towers, 4 times more expensive for only a minimal increase in performance, and a hybrid system. And of course, you can derate the unit. I mean, that's one good way to diminish the flow or to decrease the flow, but the problem with that obviously is reliability and profitability of the facility. But sometimes facilities under the proposed rule would be faced with this Hobson's choice of the only way that they can come into compliance with some of the performance requirements was to derate the facility, derate the unit. Another form of entrainment controls is wedge wire screens. This is an intake. This is an offshore intake that actually puts the intake out into the source water body. The advantages are that this can actually this is one of the technologies that addresses both impingement and entrainment. Problem is, again, you can't use it in all water bodies, and can be fairly expensive, pretty expensive. We did this at our Eddystone plant on the Delaware a number of years ago. Okay, so what's the regulatory history? This is a long way of saying that it was a long time to get to where we are. The EPA has actually been trying since 1977 to get a final rule in place. It's been overturned twice. By the D.C. Circuit, once on a challenge brought by industry, more recently in 2004 in a challenge brought by the Riverkeeper. The recent history is that there was a consent decree that was put in place that divided existing facilities into 3 phases. New facilities, the rules published by 2001, so if you have any new generating plant must have closed cycle cooling. And to some extent that's fair. I mean, you build it with closed cycle cooling in mind. You're not retrofitting an existing system. It's a cost going in, and you know you're going to have to build it. Phase 2 was for the large steam generators, and that regulation was finalized in 2004. And then there was Phase 3, which are existing facilities that were not covered under 1 or 2. And this is where a lot of manufacturing facilities get picked up, like refineries and petrochemical facilities. As I said, Phase 1 requires new facilities to have closed cycle cooling. The Phase 2 rule was finalized in 2004. The industry liked this rule. There was a lot of flexibility in it. It was so long ago I can't actually remember what it required. But we liked it, and we were 3 years into implementing it when the Second Circuit Court of Appeals in New York essentially invalidated most of the provisions in the rule, and there was really nothing left. The rule was Swiss cheese once the Second Circuit was finished with it, so the EPA just said, well, there's really not much here left to operate or to regulate in terms of the regulation, so they just withdrew the rule. And we all went back to best professional judgment as exercised by the state permitting directors. We got a proposed rule in April 2011, and there was a couple of notices of data availability. And finally, the amended settlement with the Riverkeeper required the final rule in May of 2014. So this is not an atypical, well, I guess since 1977, it's a fairly long time, but I mean, this shows you some of the bumps in the road. Once you get a final rule, sometimes you're not there because of the litigation. And in this one, we were 3 years into implementing the rule. Now, we hadn't done any capital construction projects, probably had not even determined best technology available, but we're doing the studies and the analyses, the technical studies that were required under the rule to get to the point of what was best technology available, So that could be, so that the agency would agree with that determination and put it into your permit. At the time, the fatal flaws, and these are the more significant ones, the impingement standards really weren't very flexible, and they were difficult to attain. They were supposedly based on, there was an impingement mortality limit that was based on the traveling screens, the Fletcher-Ristrov screens, et cetera, and you couldn't have more than 12% mortality. Problem was, there was no guarantee, even if you put in that technology, that you're going to reach that goal, and there was no way out. So that clearly was not a very predictable result when management puts in a compliance solution. They want assurance that that's it, and they're done. And we didn't have it there. Surprisingly, the way closed-cycle cooling was defined, a lot of facilities that had closed-cycle cooling did not meet the standard. There was a new definition, and much different than even the one in the Phase 1 rule. And that was sort of strange. I think a good number of Exelon's plants with closed-cycle systems, like the Limerick plant in Pennsylvania that was built with cooling towers, suddenly did not qualify as having closed-cycle cooling. It was really bizarre. That's because they had this notion of cycles of concentration had to be 3 or greater. I won't get into what that means, but it was really sort of a tangential kind of measurement, operating measurement. Cooling ponds cannot be waters of the U.S., which created problems for those cooling ponds that were regulated as waters of the U.S., but still constituted part of a closed-cycle cooling system. And then there was a clarity and certainty needed for application of the cost-benefit test. The old rule had a cost-benefit test. You didn't have to put in cooling towers even if it was the best technology, if the cost of putting it in the towers was significantly greater than the benefits. And of course, the problem with determining the benefits of a particular environmental solution, when you're dealing with essentially with fish, you're not dealing with human health impacts, you're dealing with environmental and aquatic systems, is how do you determine the benefits? And EPA came up with this theory of it had existed in the field before, but it was essentially, there was something called non-use values, which are values attributed to having healthy aquatic systems apart from commercial and recreational fishing, and you would determine how much the public would be willing to pay, with knowing that there were healthy aquatic systems in terms of increased electric bills. And this turned the proposed rule from being 50-1 cost to benefit to being 5-to-1 benefit to cost once the EPA did this public survey, if you will, telephone survey. So the problem was that even if the industry likes cost benefit, but if the agency is going to put its hand on the scale and tilt it in favor of overestimation of the benefits of a particular rule, then even though cooling towers are not BTA per se, we were wary of all sorts of things in the rule that might lead us or steer the permitting director in that direction. And certainly this cost-benefit test using non-use values and public opinion surveys to value how much more the public would be willing to pay for the assurance that there's healthy aquatic systems, the aquatic systems are being saved from once-through cooling systems, was really a significant issue. And this is one that the EPA has utilized in a number of other rulemakings and initiatives. So willingness to pay, non-use benefits, Google that and you'll see that the EPA is trying to implement that concept in a number of other projects and rulemakings, and even though we addressed it in this rule, it's only a temporary success, and we're going to have to be very watchful that if that is to be used in the future, that it be done in a way that is signed, that the surveys are done in a way so that they're reliable and statistically significant. So this was the watch list I put up at the last meeting, and this is probably a good summary of what the rule says. Will the deadline be extended? I was giving this presentation on October 30th, 2013. The rule was scheduled to come out on November 4th. The first question, will the deadline be extended or will the rule come out? Yes, the rule was extended actually several times. Impingement controls, is there flexibility for site-specific compliance alternatives? Yes, there's now 7 options, so it's very flexible from the impingement side of things. On the entrainment side of things, will definition of closed-cycle cooling accommodate existing systems? Yes. Anything that was problematic in the way of cycles of concentration and other peculiarities in the definition under the proposed rule have now been cleaned up and addressed. The role of cost-benefit analysis. Will states be required to include a cost-benefit analysis in its entrainment determination? Yes, that's a good thing. We want cost-benefit to be part of that equation. But the non-use benefits, the surveys I just alluded to, that EPA survey will not be used as guidance or precedent for the states. The states are not required to use that survey to determine non-use benefits. Will repowered, rebuild, or replacement units be considered new units and be required to install closed-cycle cooling before startup? The answer to that is no. I didn't really talk about that, but I'll address that in a little bit. There was a possibility that we were moving into a new source review standard for the water rules, so that if you made significant modifications to a plant, like an extended power upgrade at a nuclear facility, that could make that facility, that unit, a new facility, and closed-cycle cooling would be required from the time that EPU commenced. And that was extremely problematic. And then the Endangered Species Act. What's the role of the U.S. Fish and Wildlife Service and the National Marine Fisheries Association in the NPDES permit process? This is one which had a not favorable outcome from industry. Good, bad, or indifferent, the services are now part of the formal permitting process and will have a say if there are threatened or endangered species in the active zone in front of the intake, and that could really lead to a lot of complexity and uncertainty as the rule is administered. When will the next round of litigation begin? Well, Riverkeeper has already announced that it will challenge the rule once it becomes final, so we know there's going to be litigation. That was a certainty. I'd be in meetings with EPA and they say, look, we were in here with Riverkeeper and the environmental groups last week. We know we're not going to please everybody, and this rule is going to be litigated one way or the other. And unfortunately, that's sort of where we are in the regulatory world. Overview of the final rule. It was signed by Gina McCarthy in May of this year. Becomes effective 60 days after publication in the Federal Register. That has not yet occurred. My understanding is the latest word from EPA is that it's about 4 weeks before publication in the Federal Register, and then 60 days after that, so we're looking at probably like a mid-September effective date. The rule is flexible, takes into account specific characteristics, site-specific characteristics. This is an interesting tidbit here. If you have clients that are not steam electric generating units, it applies to any facility that uses more than 2 million gallons a day, at least 25% for cooling purposes. So they estimated that 544 power plants would be included and subject to the jurisdiction of the rule, but 521 manufacturing facilities. Now, and remember, these were the guys that were in Phase 3. Well, what happened was Phase 3 got conflated and included in Phase 2. So I used to, when I did this presentation and there were other industries represented, I would say, you guys are sitting there fat, dumb, and happy. Well, guess what? The proposed rule says you're now going to be subject to the same standards. Now, to be sure, the requirements of the rule will not be as stringent for these facilities, but it's still part of the process that they will need to go through for their permits, and they must be attentive to this rule. The rule does not mandate closed cycle cooling for existing facilities. Qualifying closed cycle systems will satisfy the final rule's impingement standard. Under the proposed rule, the best technology would only satisfy the entrainment standard and not the impingement standard, which was sort of crazy. Now, It does satisfy the impingement standard and will probably satisfy the entrainment requirements. As I said, the definition has been broadened, and new units at existing facilities must use closed cycle cooling, but the definition of new unit has been greatly improved. It's essentially a newly constructed standalone units at an existing facility. So if you do a significant modification, like an EPU, you're changing out your condenser or your turbines, more likely your turbines if you're doing an EPU, then this will not trigger the closed cycle cooling requirements. You will not be a new facility, you will not be a new unit, you will be an existing facility. And this one ended up very positively. There's a pretty cool backstory to this, so if you want to get into some information, here's a plug. Come to my, you might want to attend my breakout session. The impingement standards, as I said, you can select from one of 7 compliance options. You can, if you have closed cycle cooling, you're good. You can reduce your design intake velocity, which means that the lower the velocity, 0.5 feet per second, the fish can swim by the intake. Existing offshore velocity caps were recognized as a compliant technology. Modify traveling screens that incorporate the various protective measures for fish as a presumptive technology. And very broadly, a site-specific system of technology, management practices, or operating measures would satisfy the rule. So it could very well be that if your facility was designed to minimize impingement or entrainment, we have a facility at Peach Bottom where we have an offshore intake, but it was designed specifically with a velocity, through-screen velocity, to minimize the impact on the non-fragile species in the Susquehanna River. We certainly intend to make a run and show that that is best technology available for impingement. There's also a de minimis rule. There's some facilities that literally were impinging dozens of fish a month, period. And the EPA had the position that alone suffices adverse environmental impact in the proposed rule. The proposed rule now has a de minimis exception, which is essentially operated and administered at the discretion of the state permitting agency. And if you've got a low capacities, peaker kind of unit, then you can apply for a less stringent test. Gray water, if you use gray water as opposed to fresh water from the source water body, that qualifies as an exemption. And one thing that was interesting is that the new rule now allows you to align your impingement and entrainment remedies or requirements, so that the old rule said you had to put in impingement within 8 years and then entrainment whenever it was ultimately decided what it was. Well, that left you open to whatever you had done for impingement might have to get ripped out or changed. So there's now an alignment there of the schedules. The way that it works now is you first determine with your agency what the entrainment standard is, and then within, as soon as practicable thereafter, you determine what the impingement standard is and then implement that. Entrainment, there's no specific requirement set totally on a site-specific basis. The permitting director has to consider a number of things. They're the top 5 there. All of these things were issues that we had stressed would impact the decision whether towers were available at a particular facility. You can see social cost and benefits there at the bottom. And then the director may, but is not required to consider the factors down below. We, at Oyster Creek, we decided in a nuclear plant in New Jersey, single unit, 650 megawatt plant, we got an NRC extension that would have taken the plant out to 2029. We were required by the NJDEP in a draft permit to put in cooling towers. There was no way economically could that plant sustain that cost. And so we argued all of these things into the NJDEP that, it's not the best technology available. And we reached a settlement to close the plant early in 2019. So it just shows you how these factors can play in, and and now we have more guidance about how these factors, what weight the factors can and should be given. Endangered Species Act provision, this is the last section. Essentially what this requires is that when you fill out your application for renewal, for your permit renewal, you must indicate whether there's any threatened or endangered species in the area around the intake. What exactly that means isn't really certain, but each permit must be then, prior to the time the draft permit is published, the EPA is required to send it to the U.S. Fish and Wildlife or the National Marine Fisheries Service for their review, irrespective of whether you indicated that threatened or endangered species are involved. And this gives the services an opportunity to take a look at the site-specific characteristics and determine whether extra provisions are needed for the protection of threatened or endangered species. This is sort of a wild card. These agencies have not traditionally been involved in the permitting process, so we'll have to see how this plays out. The good news is that if a permittee does implement the requirements that are recommended by the services, then you will have, the permit will provide an incidental take authorization. The bad news is we don't know whether that's legally justified under the Clean Water, under the Threatened and Endangered Species Act, so I'm sure that'll be an issue that is further litigated by Riverkeeper. So this injects a wide level of uncertainty. And the final point I want to make, which I couldn't cover here, is that when the rule becomes effective, there's going to be a host of studies, analyses, biological sampling that will need to be done. When that needs to be done is tied to your the renewal date of your MPDS permit. There are provisions that allow the director to modify that schedule so that if, for example, you're only given 3 years, your permit comes up for renewal in 3 years, you're not going to get a 2-year impingement and entrainment study done in all likelihood by that point in time. So you can go into the director and get relief for the schedule in the permits. But that is a very confusing rule. I'm working on a permit now for a Peach Bottom nuclear facility in Pennsylvania. I've been working with the Pennsylvania DEP, and we're just scratching our heads as to what the compliance schedule might mean for this particular permit. The other uncertainty is that it's tied to the effective date of the rule, which of course hasn't occurred yet since this hasn't been published in the Federal Register. So be very attentive to those requirements as well. Even though it's a relatively successful outcome, there's a lot of work that needs to be done over the next few years. I'd like to, with all due respect to Shannon, I'd like to tease our government affairs people saying, well, you guys, the rule's final, you sort of move on to new challenges, whereas Rich and myself, the operators and the lawyers have to work their way through to ensure that all the flexibility in the rule comes to fruition in our final operating permit. So this is going to go on, and litigation will go on, and there'll be 8-10 years before probably this technology needs to be implemented, but there's a lot of work that needs to be done between now and then. Okay. I think I used all the time. Surprise, surprise.
Any questions from the audience?
Any questions?
Rich. Oh, sorry, okay.
Thank you very much. Jay Coggins from the University of Minnesota. You talk about a 24% mortality limit, and I'm just wondering, is that on the entrainment? Or
Impingement.
Impingement, yeah. 24% of what? Of the
fish that are
in
impinged?
the river?
No.
Fish that are nearby?
Fish that get impinged on the screens. So that what you have to do is that you run a seine out there, and you sort of run a sample. You sort of do a pilot, and you determine how many fish get impinged on the screen, and then you have to, and it's latent mortality, so it's how many fish die within 24 to 48 hours of having been impinged on the screen. So you have to take those fish and put them in aquariums and then see if they survive a minimum of 24 hours. And then if they don't, they're deemed to have obviously died. So you take a look at the number of fish that are impinged, how many survive the 24 to 48 hour period. I never understood the 48-hour period. It seems to me that you'd want to stop counting to 24 because I don't think that fish is going to get any healthier from 24 to 48. Somebody explained it to me. There is a rationale, but that was part of the problem with the rule, is that the monitoring that was required was so extensive that we were going to be setting up fish farms and aquariums just to show that we were meeting the standards under the prior rule, which were like 12% annual, no more than 31% in a particular month. So,
But does the rule not care whether there are 1 million healthy fish that don't come by
No.
my intake?
No.
Or only 20?
there is more of a recognition about that in some aspects of the health of the water body. 316A, the thermal, does take into account whether you've got a balanced indigenous fish population, but that was the problem. The way that the agency looks at whether there's adverse environmental impact is just number of fish that are impinged or entrained, and the relative health of the water body is irrelevant. Rich?
Yeah.
This is going to be a ringer question because he probably knows more about the rule than I do.
Well, I don't know about
This
that.
is a stump the lawyer question.
First of all, I wish you, Chris, and Exelon well. The state's going to have a lot to say, right? I mean, this is like 111D, where Connecticut could be different than New Jersey, which could be different than other states.
Yes.
What do you have to say about the influence that may have on the generators?
It'll be probably one of the single largest factors as to whether what you're going to be required to do is how your state feels about this. There were 5 or 6 states that supported Riverkeeper and getting the rule overturned in 2011. California, New Jersey, New York, Connecticut, Rhode Island, and I would imagine that some of those states will be equally aggressive in terms of how they interpret the rules. Those of you familiar with Indian Point, the nuclear facility on the Hudson, that issue is the issue that is holding up relicensing for that plant, is that New York DEP has taken the position that they must have cooling towers. They will not issue them a 401 water quality cert because they do not have cooling towers. So the state can actually have a very large impact there. My general experience is that the states are way behind the learning curve on this, way behind. And I mean, that's just based on my conversations with some of the regulators I deal with on a regular basis for pending permits that we have. And it's, there's going to be a lot of questions, and there's going to be a lot of uncertainty as we go through the process. Now, on the other hand, if you're in Texas, you're probably in pretty good shape. Yeah, but that's a great question, and it really probably the single largest determining factor. Okay,
Any
well,
other
thank you for
questions?
your attention, and there'll be opportunities to ask more questions at the breakout.